friends, or if this is your first time, welcome. This is Michigan Crime Time, and I am your host, Jess. Today, we are going on a little adventure to the capital city of Michigan, Lansing, and these are arraignments from last weekend. It took me a little while to get through all of the editing that I had to do for this video. Anyways, I hope you and yours have a very safe 4th of July if you are in the United States, and if you're a northern neighbor in Canada, mind your fires, people. It's a little hard to breathe down here. Have a happy and safe Indigenous Peoples Day and Canada Day. And with that, let's get over to Judge Stacia Buchanan's courtroom. P.S. These people can't keep their hands to themselves. They need to go back to school, like kindergarten or whatever grade we learn to keep our hands to ourselves.
Gerald Lawrence.
Hello, Mrs. Buchanan. How are you?
Fine, thank you. On the record in state of Michigan versus Gerald Savoy Lawrence. Appearance, please.
Good morning, Your Honor. Jared Austin, appearing on behalf of Mr. Lawrence today for the purpose of this hearing only.
And are you Gerald Lawrence?
Yes, ma'am.
Thank you. Mr. Lawrence, today's the day for your arraignment. What I have here is a felony complaint. This alleges the on or about June 24th, 2023 at Maplewood Avenue and Norman Street in the city of Lansing, Ingham County, Michigan. Count 1, child abuse 3rd degree, that you did knowingly or intentionally cause physical harm to a child. That is a felony punishable by up to 2 years in prison or probation for up to 5 years. Count 2, child abuse in the 4th degree, that you did knowingly or intentionally commit the following act or acts that under the circumstances posed an unreasonable risk of harm or physical injury to a child by pushing or shoving the child. This is a misdemeanor punishable by up to 1 year or probation for up to 5 years. I have a habitual offender second offense notice. It says, take notice defendant was previously convicted of a felony or an attempt to commit a felony in the on or about January 29th, 2020, he was convicted of the offense of delivery or manufacture of a controlled substance in the 30th Circuit Court of Ingham County, State of Michigan. Therefore, defendant is subjected to enhanced penalties of 1.5 times the maximum sentence on the primary offense or a lesser term. The maximum penalty cannot be less than the maximum term for a first conviction. So that means count 1 being a felony would, instead of being a 2-year felony, be a 3-year felony. The misdemeanor will still be a 1-year misdemeanor. Do you understand the charges and the possible penalties?
Yes, ma'am.
You have the right to have an attorney in this matter. If you'd like to have an attorney, but you don't believe you can afford one, we can see if the public defender will represent you. You have the right to have a trial. That could be by jury. You have the right to remain silent. Anything you say orally or in writing will be used against you. You have the right to have an attorney present with you during any questioning by law enforcement. Would you like a public defender to assist you?
Yes, ma'am.
Okay.
I'm supposed to be here for domestic violence against my son. Nothing had nothing to do with it. Child abuse. I haven't even seen the boy. I haven't even had a chance to touch him.
Stop. I'm reading you the charges. The charges, because it is a minor and it is your child, they charge child abuse, not domestic violence. Do not comment on the facts of the case, because today's not the day to do that, and anything you say will be used against you. All right. Now, because that first count is a felony charge, you do have the right to have a preliminary examination. That's a hearing where the government must bring some evidence to demonstrate probable cause to believe the felony occurred and probable cause to believe that you are the person who committed the felony. Prior to that day, you will have a probable cause conference where your lawyer, the prosecutor, yourself will make sure you have all the information and evidence you need to be ready for preliminary exam. Probable cause conference will be July 6th at 8:30 in my court with Judge Buchanan. And then preliminary exam will be July 13, 9:30, also in my court. That first probable cause conference you can do by video conference if you want to, like we're doing now. So, but if you can't video conference, don't want to, your phone's broken, you're always invited in person. And then the second court date is in person, July 13, because evidence and testimony may be presented. You are required to attend in person. You understand that?
Yes, ma'am.
Okay. Now, it's my understanding that one of the kids doesn't live with you, but the other one does. You will be ordered to have no contact while this case is pending. So I guess I'm not sure where that child is right now. Is this address on Sycamore your correct address?
Yes, ma'am.
Okay.
So never mind. It's for 2 kids now. I thought it was 1.
No, it's alleged 1 count for 2 different children. So there's 1 count of child abuse 3rd degree for 1 child and 1 count of child abuse 4th degree for a different child. Okay. So, what's a good phone number to reach you at? It's my understanding that you may be on probation or parole right now. Is that right?
That is correct, ma'am. That's why the last thing I would do was risk tags. So I don't know.
Do you have a probation or parole hold on you at this moment?
I don't have a hold, but I have a parole officer, and
Yes, Your Honor. Okay, he
does
I get
have off in 3 days.
Okay.
I get off in 3 days, so I don't know. Looks like someone had other plans for me because I didn't do anything wrong.
Mm-hmm.
Someone I abused my own kid after 18 years.
I have told you to stop speaking, and you're not following.
All right, ma'am. I'm heartbroken. I'm heartbroken. I'm sorry.
Yeah. Okay. Mr. Austin on bond.
Thank you, Your Honor. It sounds like Mr. Lawrence is a long time, if not a lifelong resident of the community. He also has family ties in addition to his children. He does live locally, I believe, with his mother. He's working at least part-time, doing some side jobs, and he is currently being supervised here while on parole. As far as I'm aware, he doesn't have any prior felony convictions other than the one mentioned in the habitual offender notice. I am unaware of any prior instances involving allegations of violence. Given that, Your Honor, I would ask the court to consider granting Mr. Lawrence a reasonable bond that he proposed. Thank you.
Oh, I do have a bond request from the prosecution as well as a CCH, so I'm going to cover both of those with you. I know yesterday I tried to read the bond request before you made your allocation, but I didn't remember today. Okay, this says the prosecution is making this request for protection of the public. The defendant is on parole, probation, or pending other criminal charges. This crime involves violence towards another person. The crime was committed in the presence of children. Victims are defendant's 12-year-old and 17-year-old children. Of note, the 17-year-old has an autism diagnosis and functions more like an elementary student. Defendant is on parole out of Ingham County, and there should be a parole hold. Their request is that he have no contact with the children during the pendency of the case. They don't make a specific monetary request. The history shows conviction for domestic violence in 2011, substance conviction 2011, substance conviction 2018, substance conviction 2020, substance conviction 2005. Okay. In light of the fact that the defendant is on parole already and has a prior assault conviction and both offenses alleged are assaultive, I find that a personal recognizance bond is not sufficient to assure public safety. Bond will be set at $2,000 cash surety, subject to the following conditions. You must not leave the state without permission of the court. You must attend both your court dates and any other court dates that are set. Notify the court in writing if you change your address or telephone number. Report to pretrial services on your first business day following your release. You should get a brochure from the jail there with a phone number to call, and you'll probably have to leave a voicemail and they'll call you back. So leave a good number and take their call. Do not use alcohol, marijuana, or illegal controlled substances while on bond. Do not possess or purchase a firearm or dangerous weapon. Do not engage in harassing, intimidating, stalking, or threatening behaviors. Do not assault, harass, intimidate, beat, molest, wound, or threat. Do not have any direct or indirect contact with, and you're not to be within 2,000 feet of where they live, work, or go to school. Violation of an order of no contact can be very serious. If you violate that order, you could be arrested without a warrant. Your bond could be revoked. You could be in contempt of court, for which you can be punished by up to 93 days in jail and or $7,500 in fines, separate and apart from that which you already face. It's important that you understand that this order is about you. It's not about them. So if these children were texting you, they're allowed to do that. But if you text them back, you're the one who's under a court order. So you're the one who risks going to jail. They're calling you. You cannot call them back. If you do, you risk jail. They do not have authority to give you permission to violate this order because it's not their order. It's the court's order. So if they invited you to meet up with them for some reason, you went, you'd be risking jail. You understand how that works, sir?
Yes, ma'am.
Okay. All right. We've covered bond and conditions and court dates. Anything else, Mr. Austin?
Nothing additional on behalf of Mr. Lawrence, Your Honor. Thank you.
Mr. Lawrence, you are all set.
Thank you. You have a good day.
On the record in state of Michigan versus Patrick Andrew Hayward.
Thank you, Your Honor. Good morning. Jared Austin appearing on behalf of Mr. Hayward for the purpose of this hearing only.
Thank you. And you, sir, you are Patrick Andrew Hayward?
Yes, ma'am.
Thank you. Mr. Hayward, you're here for an arraignment. What I have here is a felony complaint. This alleges that on or about June 24th, 2023 at Pennsylvania and Hickory in the city of Lansing, Ingham County, Michigan, you did, count one is receiving and concealing a motor vehicle that is stolen, that you did buy, receive, possess, conceal, or aid in the concealment of a 1999 black Honda motorcycle, a stolen motor vehicle, knowing or having reason to know that the motor vehicle was stolen, embezzled, or converted. That's a felony punishable by 5 years and or $10,000, or 3 times the value of the motor vehicle, whichever is greater. Count 2, possession of methamphetamine, that you did knowingly or intentionally possess methamphetamine. That is a felony punishable by 10 years and or $15,000. Do you understand the charges and the possible penalties?
Yes, Your Honor.
You have the right to have an attorney in this matter. If you cannot afford one, the public defender may represent you. You have the right to a trial. That could be by jury. You have the right to remain silent. Anything you say orally or in writing will be used against you in court. You have the right to have an attorney present with you during any questioning by law enforcement. You understand these rights?
Yes, Your Honor.
And would you like a public defender to assist you in this matter?
Yes, Your Honor.
Okay. Now, since you do have felony charges, you have the right to have a preliminary examination. That's a hearing where the government must bring some evidence to demonstrate probable cause to believe that these felonies occurred and you're the person who committed these felonies. Prior to that date, you'll have a probable cause conference. That's an opportunity for you, your lawyer, and the prosecutor to make sure you have everything you need, all the evidence in order to be prepared for your probable cause or preliminary exam. So probable cause conference will be July 7, 8:30 with Judge Simmons. Should be the same paper you have there. It should be the same one I have here.
Yes, ma'am.
And then preliminary exam, July 14, 8:30, also Judge Simmons.
Yes,
what
ma'am.
you should know is that very first hearing can be done by video conference if you like we're doing now. But if you don't want to, can't, phone's broken, just come down here, don't miss. And then the second one is in person for sure. The second hearing is down in person. You understand the obligation to come in person?
Yes, I'm gonna show up regardless, yeah.
Okay, good. Now, the address they gave me for you on Donald Street, is that still your address?
Yes, it's my mother's house, yes.
Okay. Just looking to see. I don't think they gave me a phone number for you. Do you have a phone number you can be reached at?
I don't. My mother has a phone number I can be reached at.
Okay, what's your mom's number? Okay. Are you on probation or parole in any court?
No, ma'am.
All right, Mr. Austin, I have the history here, and it's 2016 substances, 2021 substances, and that's it. I see nothing else on his Michigan history.
Yeah, I have no other criminal record.
Okay, on bond, Mr. Austin.
Yes, thank you, Your Honor. My understanding from speaking with Mr. Hayward, that was the extent of his criminal history as well as nonviolent drug offenses. Certainly these allegations are nonviolent in nature. He enjoys a presumption of innocence on those. He's lived here locally nearly his entire life. He has family ties. As he stated, he lives here with his mother. He has very little income and resources. I would ask the court to strongly consider personal recognizance release. Thank you.
Please.
Yeah, I'm just trying to think of one thing here. So my issue is twofold. One is if people, it looks like you may have a persistent substance abuse issue, and that affects the court in that people who are using substances miss court dates. So we need to try and make sure that you don't miss court dates. And the other is, of course, the alleged crimes. Use of substances, I guess, is a personal health choice, being a crime, but when it starts to affect other people, meaning other crimes occur because of substance use, that's when the court, of course, is concerned for the community. So I'm just trying to decide whether to order some, but I'm probably not talking right now, sir.
Yeah, okay.
Probably not. I'm just trying to decide. It's not the issue of whether it's a PR bond or not. It's whether you should test while on bond to assure that you're sober and showing up for court.
Yes, I should. Because I'm clean right now. I've been clean for 9 months.
Well, that would be great. Okay.
This thing that happened is it's completely.
Don't talk about the thing that happened. Don't talk about the thing that happened.
I'm sorry. I apologize. I'm sorry. But yes, I should test. I should test. Absolutely 100%. You'd be very surprised in knowing that I've been clean for 9 months now. So you tell me how fat I am.
Okay, bond is going to be ordered in the amount of $5,000, personal recognizance, subject to the following conditions. You must show up for your court dates. I gave you 2. Don't leave the state without permission. Don't commit crimes. Notify the court in writing if you change your address. You must report to pretrial services on your first business day after your release, and you should get that phone number there in a little folded piece of paper. Do not use alcohol, marijuana, illegal controlled substances, one-time, monthly, random urine screen to assure you're following the court order for sobriety, and no firearms, ammunition, or dangerous weapons while on bond. Do you understand your bond conditions?
Yes, ma'am. Yes, I do, Your Honor. Thank you very much.
Mr. Austin, anything else we need to cover for Mr. Hayward today?
I have nothing additional on behalf of Mr. Hayward, Your Honor. Thank you.
All right, Mr. Hayward, when you contact pretrial, they'll set up that one-time monthly testing. I tried to keep it, very limited testing because it could cost you money. That's why it's only one-time monthly.
Thank you very, very much. I appreciate that, Your Honor.
Okay. And I think that's our last arraignment.
Yeah, thank you, Mr. Austin, as well.
Thank you.
You're welcome, sir. Good luck.
We'll start with the fresh complaint, and then we'll go to the bond violation. On the record in state of Michigan versus Keith Richard Eskin. Appearance, please.
And good afternoon, Your Honor. Gerald Austin appearing on behalf of Mr. Eskin. My appearance is limited for this hearing only.
Thank you. And you, sir, are you Keith Richard Eskin?
Yes, ma'am.
Okay. What I have here is a felony complaint. This alleges that on or about June 23rd, 2023 at 1534 Bailey Street, City of Lansing, Ingham County, Michigan, count 1, home invasion, first degree, that you did break and enter or did enter without permission a dwelling located at 1534 Bailey Street. And while entering, present, or exiting the exiting, you committed discharge of a firearm, a felony. And while entering, present, or exiting the dwelling was lawfully present therein. That is a felony punishable by 20 years in prison and or $5,000 in fines. A consecutive sentence may be imposed for any other conviction arising out of the same transaction. Count 2, discharge in or at a building that you did intentionally discharge a firearm at a facility that you knew or had reason to believe was a dwelling or potentially occupied structure, and or in a facility that you knew or had reason to believe was a dwelling or a potentially occupied structure in reckless disregard for the safety of another. Felony, 10 years and or $10,000 with mandatory forfeiture of the weapon or device. Count 3, that you did without just cause knowingly kill a dog. Felony, 4 years and or $5,000. A consecutive sentence may be imposed for any other conviction. Not more than 500 hours of community service. Court may order a psychiatric evaluation. Court may order cost of prosecution, care, housing, or veterinary care as applicable, and may be ordered not to own or possess an animal. Do you understand those 3 charges and the possible penalties?
Yes, Your Honor. I have a quick question, Ms. Buchanan.
Well, you can ask a question. I don't know if I'll answer it. Go ahead.
Okay, thank you. So I was just told by the officers that I was being charged with something totally different, and now I'm getting told I'm getting charged with discharge at a building.
Yep, so whatever I say is that's the whole purpose of arraignment. So you can officially hear the charges. So I have the official court document, and the charges I'm telling you are the official charges in this file.
Yes, Your Honor, thank you.
Okay, so the 3 charges are home invasion 1st degree, discharge in or at a building, and animal killing 3rd degree. You have the right to have an attorney in this matter. If you'd like to have an attorney and you don't believe you can afford one, you may be able to get a public defender to represent you. You have the right to have a trial. That could be by jury. You have the right to remain silent. Anything you say orally or in writing will be used against you. You have the right to have an attorney present with you during any questioning by law enforcement. Do you understand these rights, Mr. Eskin?
Yes, Your Honor.
Would you like a public defender to assist you in this case?
Yes, Your Honor. And when you have a chance, can I ask one more question?
Again, you can ask. I don't know if I can answer. Go ahead.
No. So I'm being charged with discharge of a firearm, but when I was arrested, the officers didn't locate not one firearm. So how is that possible?
So probably shouldn't talk about your case, but just because they didn't catch you with it doesn't mean there isn't other evidence that may say that you had a firearm. So just because you weren't caught with it doesn't mean that means they can't charge you if they have other evidence. All right, since you have felony charges, you have the right to have a preliminary examination. That's a hearing where the government must bring some evidence to demonstrate probable cause to believe the felony occurred and probable cause to believe that you're the person who committed the felony. Prior to that day, you'll have a probable cause conference to make sure that you have all the evidence and information you need to be ready for preliminary exam. Your probable cause conference will be July 7 at 8:30 a.m. with Judge Ward. And then your preliminary exam will be July 14, 9 a.m., also with Judge Ward. Now, that first hearing may be done by video conference like we're doing right now, but the second hearing will definitely be in person because evidence and testimony may be presented at that time.
Yes, Your Honor.
Mr. Eskin, they've given me an address for you on Genesee. Is that a correct address to use?
Yes, Your Honor.
Okay. They've also given me, nope, I thought they gave me a phone number, but I don't see it. Is there a phone number you can be reached at, sir?
Yes.
Okay. All right. I've been told that you may be on bond from circuit court. Is that right?
Yes, Your Honor.
Are you on probation or parole in any court?
No, Your Honor.
Mr. Austin, before I ask you about bond, I am going to read into the record the prosecutor's bond request because I believe you and your client are entitled to know everything that the court sees and considers in order to make a bond decision. The prosecutor's bond recommendation requests that we review this bond, keeping in mind protection of the public. The defendant is on parole, probation, or pending other criminal charges. Based on our conversation, I think they mean the latter. The crime charged involves violence towards another person. The crime charged involves use or possession of a firearm. Defendant is currently on bond to 30th Circuit Court for gun charges, has extremely lengthy juvenile history, including home invasions, guns, and other dangerous felonies. The people respectfully request $250,000 cash bond reflecting the continued pattern of criminal behavior and non-deterrence that being on bond has given this defendant. He poses an extreme risk of danger to the community. And then they just request a money bond, as they said, and not that he be ordered not to possess a firearm. All right, Mr. Austin.
Thank you, Your Honor. Well, I can appreciate the seriousness of the allegations. In this case, they are allegations. At this point, the presumption is that Mr. Eskin did not commit them. What I can say, he appears to be a longtime member of the community. He has family ties, I know, including his mother. He also has a minor child. Mr. Eskin informs me that he's also working. And given that, Your Honor, I think bond and the amount if the court is to set a cash surety bond, I would just ask that it be far less than what the people are requesting. I would ask that it not exceed 30,000. Thank you.
Is Mr. Eskin working at this time?
Yes, he informs me that he's working.
Okay. In addition to the bond recommendation, I do have a copy of Mr. Eskin's CCH, and it substantially is similar to that which is alleged by the prosecutor. Several sort of juvenile encounters, and then I believe there was a probationary term that was revoked, and I believe his special status was revoked along with that. Yeah, it was definitely revoked the end of 2021 for a gun charge. Looks like 2 counts, gun charges, revoked youthful offender status. Based on the fact that Mr. Eskin has prior gun charges, convictions, unsuccessfully completed a term of probation, is on bond, and the allegations in this case are that he kicked in the door of a resident and shot and killed a dog, threatened a resident with a firearm. Bond will be set at $100,000 cash surety.
Yes.
Subject to the following conditions. Mr. Eskin, you of course must attend court dates. I've given you 2. Do not leave the state without permission of the court. Do not commit crimes. You must report to pretrial services on the first business day following your release. Do not use alcohol, marijuana, illegal controlled substances. Do not possess or purchase a firearm or dangerous weapon. Do not engage in harassing, intimidating, stalking, or threatening behavior. Do not assault, harass, intimidate, beat, molest, wound, or threaten. You are not to have any contact with. You're not to be within 2,000 feet of where they live, work, or go to school. If you violate an order of no contact, you can be arrested without a warrant. Your bond could be revoked. You could be in contempt of court, for which you face up to 93 days in jail and or $7,500 in fines, separate and apart from that which you already face. This order is about you. It's not about them. So if they were texting you, if you text them back, you go to jail. If they're calling you, if you call them back, you go to jail. They do not have authority to give you permission to violate a court order, because it's not their order. It is the court's order. So if they invited you to meet up with them and you went, you'd still be risking jail. You understand that?
Yes, Your Honor. I have one question though. Did you say 100,000 cash surety or 10%?
Correct. I said cash surety.
Okay, thank you. I just wanted to.
Now, we have one more order of business here, which is I've been given a bond violation, which I believe is that this event that is alleged to have occurred violated your bond at the 30th Circuit Court. I do not have in my hand the case number for that, but maybe Mr. Austin has it, or maybe I can look it up. It's
yes, Your Honor, it appears to be 23080FH.
080FH.
Correct.
Okay, I hope I did that. 080. Okay. So in state of Michigan versus Keith Richard Eskin 23080FH, it is alleged, Mr. Eskin, that you are on a bond and that the bond prohibited you from committing any crime while released and from possessing a firearm. If you did violate your bond conditions, you will, your bond that you previously were on could be forfeited. You could also be in contempt of court, for which you could be sentenced to up to 93 days in jail and or $7,500 in fines, separate and apart from that which you already face. For contempt of court, you do have the right to have an attorney, and I believe you already have an attorney on this offense. Is that right, Mr. Austin?
Yes, Your Honor. Mr. Goodrich represents him on that file.
Okay. You also have the right to have a trial, not by a jury, but just by a judge. But at that trial, it'd have to be proven that you violated a court order beyond a reasonable doubt. Since I do not have this file, it's not my file, you'll be remanded until you see a circuit judge regarding your bond violation.
I got $10,000 right now.
So from my understanding, my bond will only be remanded until I go to court for my circuit court judge, right?
So on one file, you need $100,000 cash surety. And then on the other file, the circuit court judge will decide what to do about your bond violations. So that judge could reinstate your bond. That judge could establish a new bond. That judge could keep you in jail. I don't know what they'll do.
Okay, so I have to wait till my next court hearing for that day or something to see my judge for that charge?
I think what will happen is they'll set a court date fairly quickly, maybe in the next week or so, in order to see you about your bond violation. So you should see a circuit judge pretty quickly.
Okay, and can the circuit judge? Never mind. You're right. Okay, thank you.
All right, I think that's it for Mr. Eskin. Is that right, Mr. Austin?
I have nothing additional, Your Honor. Yes, thank you.
All right, thank you. On the record in State of Michigan versus Nicole Marchand Jones.
And good afternoon, Your Honor. Gerald Austin appearing on behalf of Ms. Jones for her arraignment only.
Thank you. Are you Nicole Marchand Jones?
Yes.
Thank you. Today is the date of your arraignment. What I have here is a felony complaint. This alleges that on or about June 23rd, 2023 at 1421 East North Street in the city of Lansing, Ingham County, Michigan. Count 1 is assault with a dangerous weapon, that you did make an assault upon with a dangerous weapon, a pistol, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder. That is a felony punishable by up to 4 years in prison and or $2,000. DNA to be taken upon arrest. Count 2, felony firearm, that you did carry or have in your possession a firearm, a pistol, at the time you committed or attempted to commit a felony, that being the assault with a dangerous weapon. Felony 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. Mandatory forfeiture of the weapon or device. Count 3, that you did make an assault or assault and battery upon an individual with whom you've had a child in common or a resident or former resident of your household. That's known as domestic violence, misdemeanor, 93 days and or $500 in fines. Do you understand these 3 charges and the possible penalties?
I was the one attacked. I was only
that's not what I asked you. Okay, Ms. Jones, if you would like a chance to be out on bond, you need to listen to the question and understand the proceeding. This is an arraignment. We do not talk about the facts of your case. Do you understand the charges and the possible penalties?
Yeah.
Okay. You have the right to have an attorney in this matter. If you cannot afford one, we can see if a public defender will represent you. You have the right to a trial. That could be by jury. You have the right to remain silent. Anything you say, orally or in writing, will be used against you in court. You have the right to have an attorney present with you during any questioning by law enforcement. Do you understand these rights?
Yeah.
Would you like a public defender to assist you?
Yes.
Okay.
But these are really what I have to be charged with.
This is what you're accused of. That's why the next step is you'll have a preliminary examination. That's a hearing where the government.
Me.
Pardon?
Nothing is actually charged like on my record yet.
So you're charged. So your criminal history will show that there's an arrest and fingerprints were taken, but that's like a law enforcement record. That's a law enforcement record. And if you're found not guilty, you can get those fingerprint records destroyed. But as of today, you've been arrested and accused of 3 crimes.
Okay.
Okay. Now you have the right to have a preliminary examination. That's a hearing where the government must bring some evidence to demonstrate probable cause to believe that the felony charges occurred and probable cause to believe that you're the person who committed the felonies. You will have a probable cause conference before that day where your lawyer, yourself, and the prosecutor can make sure you have all the information and evidence you need to be ready for a preliminary exam. The probable cause conference will occur July 7 at 8:30 a.m. with Judge Ward. And then you'll have your preliminary exam July 14 at 9 a.m. That will be with Judge Ward as well. Now that first hearing, the probable cause conference, can be done by video conference like we're doing now if you like. Of course, you're always invited to come in person if you cannot video conference. The second date, because it's an evidence and testimony type hearing, you will need to be present here in person at the courthouse in order for that hearing to occur. You understand your obligation to come in person for that?
Mhm.
Is that a yes?
Yes, I heard you.
Okay, thank you. Now, one of the conditions of your release is going to be to have no contact with. So
Yeah.
I need to get an address for you.
For me, I actually don't have an address. I was living with him at his auntie house where he tried to kill me with his gun, but here I am because I put it in my release.
Okay, so whether what they say happened occurred or what you said happened occurred, you probably, it's a good idea to be
Two
aware.
cameras right there on his auntie house that can prove.
Okay, but whether you were accused of a crime or whether he committed a crime on you, you shouldn't be at that address.
The address,
I was
staying there. I was staying there with him. I don't have no other address to give you, but that same exact one where it happened.
Okay, well, if you have no other address and you're unwilling to cooperate, I will have no choice but to keep you in jail.
I mean, I could give you my stepdad address to mail it to me. I wasn't gonna go there, but that was where I was staying.
Yes, but you won't be anymore. So that's why I'm asking.
I won't go there at all by him. Trust me. After this, it's nothing.
The phone number they gave me for you that ends 6726, is that a good phone number?
No.
Okay.
A good phone number would be 517. That would be my grandma's number.
Okay, that's the number I just asked you about.
Was it?
Yes.
I got into car accidents 2 years ago, and I get concussions after getting my head busted. So excuse me, I really didn't hear you say that. But and the address for my stepdad will be.
Well, if you're not going to be there, I'm not writing that address down.
Oh, I'll be there.
You just got done telling me that you're not going to go there.
That I'm not going to be at his address. I mean, my stepdad. I mean, I'd be there or at my friend's that's literally stays right next to him. So his is 3260, hers is 3258. Those would be literally my two addresses. They live right next door. My best friend that brought me my keys last night, that took my car and my keys into possession with the police.
You need to stop talking. You need to stop talking. So you said, is there an apartment number or anything I need with that address?
Lansing, Michigan, 48906.
Okay. Are you on probation or parole in any of the
arrested? I've never had a juvenile record or anything. No.
Mr. Austin, I'm going to read into the record the bond request from the prosecution. This says, prosecution says to note for protection of the public that this crime charge involves violence towards another person. Crime charge involves possession or use of a firearm, and it involves an intimate partner. The prosecutor is not making a specific money request, just stating that they want no contact orders for in order not to possess firearms.
Wasn't even mine.
Mr. Ms. Jones, you need to learn when I tell you not to not talk. If you keep it up, you're going to end up finding yourself at a disadvantage. Mr. Austin, please proceed on bond.
Yes, thank you, Your Honor. Speaking with Ms. Jones, she purports to me to have no prior criminal history whatsoever. I know in our system, I did not see anything other than maybe some traffic misdemeanors. She is gainfully employed. She's working. She also has children that she supports. She has ties to the community as well as family ties to the community as well, Your Honor. She has provided the court with an address where she can stay so that she can comply with the court's no contact order. The only thing I believe from speaking with Ms. Jones, Your Honor, she may have a child in common with the complaining witness in this case. And if that is the case, I would ask for some type of third-party contact. It's just a general variance on the overall no contact order. I understand the allegations involve violence, Your Honor, but the presumption is that Ms. Jones did not commit them. Given the factors that I have mentioned, Your Honor, I would ask the court to consider personal recognizance release or any alternative, a reasonable 10% bond. Thank you.
A review of Ms. Jones' criminal history shows no prior arrests in the state of Michigan. However, I do have concerns about Ms. Jones' willingness to comply with court orders based on how this entire arraignment has occurred. Bond will be set at $2,500 personal recognizance, but there will be a tether requirement for release. I'll get to that in just a second here. Ms. Jones, a condition of your release includes attending court dates. I gave you 2. Do not leave the state without permission from the court. Do not commit crimes. You must report to pretrial services on the first business day after your release. You should receive a brochure there from the jail with a phone number that you need to call. And then they will generally, you'll have to leave a voicemail and they'll call you back. So make sure you leave a good number to be reached at and that you take their call when they do call you back. Do not use alcohol, marijuana, illegal controlled substances. Do not possess or purchase a firearm or dangerous weapon. Do not engage in harassing, intimidating, stalking, or threatening behaviors. Do not assault, harass, intimidate, beat, molest, wound, or threaten. You are not to have any contact with, no direct contact, and no indirect contact, except you may have third-party contact with regarding your minor child only. It's only third-party contact, not direct contact. It's only regarding a child. If that isn't your situation, then no contact at all. You're not to be within 2,000 feet of home, work, or school. If you violate an order of no contact, you can be arrested without a warrant. Your bond could be revoked. You could be in contempt of court, for which you face up to 93 days in jail and or $7,500 in fines separate and apart from that which you already face. I will say I have authorized you can go to the residence one time to pick up your personal belongings in the presence of a police officer. It's the only way you can go there is if a police officer goes with you to grab your things. You should know this order is about you. It's not about these other people. So if they're texting you, do not text them back. If you text back, you could go to jail. They're calling you. If you call them back, you're the one who risks jail. They do not have authority to give you permission to violate a court order because it's the court's order, not their order. So even if they invited you to meet up with them and you went, you'd still be risking jail. You understand?
Okay.
Okay.
And then how do I do the bond and stuff? Like, what is that process?
So the bond is a personal recognizance bond, which means you don't have to post money to get out of jail, but you do need a tether. So they'll take you out to the county and they'll tell the tether company and they'll come over and talk to you about what you need in order to set up the tether.
Okay. Okay.
All right.
Okay.
Okay. All right. Anything else on this case, Mr. Austin?
Nothing additional, Your Honor. Thank you.
Okay. You're all set, Ms. Jones. On the record in State of Michigan versus Robert Harold Glasgow, 2001198 SM.
Thank you, Your Honor, and good afternoon. Jared Austin appearing on behalf of Mr. Glasgow for the limited purpose of this hearing only.
And you, sir, are you Robert Harold Glasgow?
Yes, ma'am.
Thank you. In this case, what I have here is a misdemeanor complaint. This alleges that on or about January 1st of 2020 at City of Lansing, Eaton County, Michigan, that you did cause physical harm to a child by repeatedly striking the child with a belt. That is an offense known as child abuse in the 4th degree, a misdemeanor punishable by up to 1 year in jail or probation of up to 5 years. Do you understand the charge and the possible penalty?
Yes, ma'am.
You have the right to have an attorney in this matter. If you cannot afford an attorney, we can see if the public defender will represent you. You have the right to have a trial that could be by jury. You have the right to see, hear, and question all of the witnesses against you at trial. You have the right to bring witnesses in your own defense, and you could get a subpoena to make them appear. You have the right to testify at your trial if you wanted to, but if you did not want to testify, the prosecutor could not use your silence against you. You have the right to be presumed innocent unless they can prove that you are guilty beyond a reasonable doubt. Do you understand these rights, Mr. Glasgow?
Yes, ma'am.
Are you requesting a public defender to assist you in this matter?
Yes, ma'am.
Okay. Are you on probation or parole in any court?
No, ma'am. I don't think so.
Well, that's something we got to talk about because the next arraignment is going to be absconding from probation. In the meantime, there is a person who you will be unable to have contact with during the time of this case. I have an address on Glenburn. Does he live at the Glenburn address with you?
No, not anymore, ma'am.
Okay. Do you still live at the Glenburn address? Is that the address I should be using for you?
Yes, ma'am.
Okay. The phone number they gave me that ends 8531, is that still a good number for you?
May I check in my pocket? I'm not good with numbers, so I wrote them down.
That's fine.
Okay.
Okay.
Okay. And we actually have, she has 2 phones, so if she doesn't answer that one, the other one is 517.
Okay. All right. Okay. Mr. Austin.
Yes, Your Honor, thank you. Speaking with Mr. Glasgow, reports to me that he's married, that he's also working. He has children that he supports as well. It sounds like this allegation is a few years old, so it sounds like he hasn't had police contact or any new charges. In the interim, he has afforded the presumption of innocence at this point. I would ask the court to take all that in consideration and consider releasing him on his own recognizance, or if the court does not feel that is sufficient, then a reasonable 10% bond. Thank you.
A review of Mr. Glasgow's Michigan criminal history only shows the charges for which I actually have to talk to him about probation. That's it, nothing else. But it does include 1 assaultive offense. Based on the fact that I'm about to arraign Mr. Glasgow for absconding, I don't believe a personal recognizance bond is appropriate to assure his appearance at court. I also am concerned that he may be in custody and that he should accrue some credit for being in custody. So bond in this matter will be set at $2,000, 10%. Subject to the following conditions. Mr. Glasgow, you must attend a court date. Unfortunately, because it's a misdemeanor offense for which you've had a warrant for a little while, I don't have the court date to give you at this moment. It's going to be sent to your address by the clerks when they come into work on Monday. Also, it's a good idea to call the court after Monday and check on your court date if you're out of custody. If you're in custody, obviously that mailing will go out to your address. And if you're still in custody on the day of your court, we would arrange to see you. Do not leave the state without permission. Do not commit crimes. You do not use alcohol, marijuana, illegal controlled substances. You must notify the court in writing if you change your address or telephone number. Do not possess or purchase a firearm or dangerous weapon. Do not engage in harassing, intimidating, stalking, or threatening behaviors. Do not assault, harass, intimidate, beat, molest, wound, or threaten. Do not have direct or indirect contact with him, not to be within 2,000 feet of where he lives, works, or goes to school. You violate the order of no contact. You could be arrested without a warrant. Your bond could be revoked. You could be in contempt of court, for which you face up to 93 days in jail and or $7,500 in fines, separate and apart from that which you already face. And I know you heard me telling other people, this order is about you, it's not about the other person. So if they're contacting you or texting you, that's something they are allowed to do. But if you contact them back, you still risk jail. You understand?
Yes, ma'am.
We'll switch to the probation file here. This is State of Michigan versus Robert Glasgow, 1701428FY. And Mr. Austin, you'll appear on this file as well?
Yes, Your Honor.
All right. Mr. Glasgow, what I have here is a file where it looks like you entered a plea and were placed on probation in April of 2017. There was a probation violation show cause initiated in February of 18 that says that you had failed to make your monthly payments and you used a controlled substance without a prescription, testing positive for marijuana at PATS on February 26 of 2018. That was followed by a bench warrant for failure to appear at your probation violation arraignment March 20 of 2018. And it appears that we hadn't seen you since. If you're found to have violated your probation, you face up to, just want to make sure, up to 93 days in jail with credit for any time that you've already served on these these 2 charges. Just looking here. Okay, I just want to copy your address over and update this file. Mr. Austin, do you have anything on your client's non-appearance or anything else to add before I decide what to do with this file?
I would just reiterate my prior comments to the court, Your Honor. Thank you.
This is a little more difficult because, Mr. Glasgow, you've been gone a long time and your original judge wrote remand on the bench warrant. However, that judge has since retired because you've been gone a while. And you have such a minimal criminal history. I do think a cash bond is appropriate in light of your absconding and non-appearance, but I don't want to leave you without any bond at all. I'll set bond at $10,000 cash surety. There will be a probation violation hearing date scheduled by the clerks when they come into work. So again, that will be mailed to your address, but if you've posted bond and you're out after Monday, you should contact the court and make sure that you are aware of your court dates so that you don't miss and end up absconding again. Because I can tell you, I considered not releasing you today. So if you ran again, you probably wouldn't get released.
Yes, ma'am.
All right. Anything else on this file, Mr. Austin?
Not on that file, Your Honor, but just a quick question on the other one, the child abuse file. It looked like the IROA had Judge Flores listed as the judge of record. Can the court confirm if that's accurate?
So the file is so old, it says Alderson, but I'm guessing both of these are going to go to Flores since he took her seat.
Makes sense. Thank you, Judge.
No problem. All right, Mr. Glasgow, you're all set.
Thank you.
All right, on the record in State of Michigan versus Prince Alexander Wallace.
And good afternoon, Your Honor. Gerald Austin appearing on behalf of Mr. Wallace for today's arraignment only.
And you, sir, are you Prince Alexander Wallace?
Yes, ma'am. Good afternoon.
Thank you. Sir, today's the date for your arraignment. What I have here is a felony complaint. This alleges that on or about June 23rd, 2023 at 1 City of Lansing, Ingham County, Michigan, count 1 unlawful imprisonment, that you did knowingly restrain to facilitate the commission of assault with intent to do great bodily harm less than murder or by strangulation, a felony. That is a felony punishable by 15 years in prison and or $20,000 in fines. There is a SOAR notice here as well that says that if there was a sexual component, I suppose, this is a Tier 1 Sex Offender Registration Act if the victim is a minor. It's Tier 2 offense if the defendant has a prior conviction for a Tier 1 offense. It's a Tier 3 offense if the defendant has a prior conviction for a Tier 2 offense. Count 2, assault with intent to do great bodily harm less than murder or by strangulation, that you did make an assault upon by strangulation or suffocation. Felony 10 years or $5,000. DNA to be taken upon arrest. Count 3, felony firearm, that you did have or carry in your possession a firearm, a pistol, at the time you committed or attempted to commit the felony of unlawful imprisonment. That is a felony punishable by 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. Mandatory forfeiture of the weapon or device. Count 4, felony firearm, that you did have in your possession a firearm, a pistol, at the time you committed or attempted to commit assault with intent to do great bodily harm less than murder or by strangulation. Felony 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. Mandatory forfeiture of the weapon or device. Count 5, domestic violence. You did make an assault or assault and battery upon an individual with whom you had a child in common or your spouse. Normally that's a misdemeanor punishable by 93 days in jail. But I do have a second offense notice that says, take notice, defendant was previously convicted of assaulting or assaulting and battering his spouse, former spouse, an individual with whom he had a dating relationship, an individual with whom he had a child in common, or a resident or former resident of his household, or of knowingly assaulting a pregnant individual by violating statute on or about March 19th, 2015, and therefore upon conviction will be subjected to an enhanced sentence, misdemeanor 1 year and or $1,000. Do you understand these 5 charges and the possible penalties, sir?
Yes, Your Honor.
You have the right to have an attorney. If you'd like to have an attorney and you don't believe you can afford one, you may have a public defender represent you. You have the right to have a trial. That could be by jury. You have the right to remain silent. Anything you say orally or in writing will be used against you in court. You have the right to have an attorney present with you during any questioning by law enforcement. Do you understand these rights, sir?
Yes, Your Honor.
Would you like a public defender to assist you?
Yes.
Okay. I will put that down. Now, you do have the right to have a preliminary examination on the felony charges. That's a hearing where the government must bring some evidence to demonstrate probable cause to believe the felonies occurred and probable cause to believe that you're the person who committed the felonies. Prior to that date, you'll have a probable cause conference where you, the prosecutor, your lawyer, all assure that you have all the evidence and information you need to be ready for preliminary exam. Probable cause conference in this case is scheduled for July 6th at 8:30 a.m. That's in my court here, Judge Buchanan. And preliminary exam will be July 13 at 9:30 a.m. That's also here in my court. That first hearing may be done by video conference like we're doing now, but the second hearing is in person because evidence and testimony may be presented. It's very important that you understand that second hearing, you must be in person. Now, thank you. One of the conditions of your release will be no contact with Ms. I understand that she may be your spouse, but do you have another address that you can stay at to keep separate from her while we sort this out?
Yes.
Can you tell me?
Sure. It is 48911 Lansing, Michigan.
Is there a apartment number or anything I need to put with that?
It's a home.
Whose place is that?
It's my mother's.
Your mom. Okay. And then they gave me a phone number that ends 4749. Is that a good number to reach you?
4749. Yes, ma'am. And can I correct it? It's Bradley, not Bailey. I said that wrong. Bradley.
Are you on probation or parole in any court?
None.
Viva had a bond request in this case. Let's see here, Mr. Austin. I do. It's this one says they're making a bond request for the protection of the public. The crime charged involves violence towards another person. The crime charged involves possession or use of a firearm and involves an intimate partner. There have been threats to kill the victim or family, recent separation or divorce, escalation of violence or risk-taking over time, acute depression or unpredictable and violent mood swings. Crime was committed in the presence of children. Defendant was intoxicated with a firearm on his person during his assaults on the victim, as well as during his highly escalated behavior toward police. Defendant made a statement along the lines of, he should have blew you away, blew the whole family away. The people request a GPS tether with victim exclusion zone and notification. And then, of course, no contact with Ms. No firearms. Mr. Austin on the bond.
Yes, Your Honor. Thank you. Mr. Wallace informs me that he has lived in our community nearly his entire life. And as the court is aware, he is married. He also has children. While he is currently unemployed, Mr. Wallace informs me that he is set to start working a new job next week. It sounds like it's been getting close to upwards of 10 years, at least since his last domestic assault conviction. Your Honor, I think there are bond conditions and safeguards that could be put in place to address any safety concerns. He does have a separate address so that he can abide by the no contact order. He also obviously has family ties to the community. I would ask the court to consider granting a reasonable 10% bond. Thank you.
So I see that Mr. Wallace's Michigan criminal history really only shows the one prior offense conviction that is the subject of the second offense notice. Anything else was actually dismissed or acquitted, so that's the only thing on there. However, it is not lost on me that it is assaultive, and this offense is alleged to be significantly assaultive. There's also information provided that there may have been law enforcement witnesses to at least part of the offense. So it seems that the likelihood of conviction of at least something does seem to be significant. The bond is set at $7,000, 10%, subject to the following conditions. Of course, you must attend your court dates, sir. I gave you 2. Do not leave the state without permission. Do not commit crimes. You must report to pretrial services on the first business day after your release. They should give you a brochure there at the jail with a phone number that you need to call them. And if you have to leave a voicemail, make sure you leave a good number and you take their calls. Do not use alcohol, marijuana, or illegal controlled substances, and you'll participate in a one-time monthly random ETG test to assure your sobriety, because this offense is alleged to have occurred with significant intoxication. Do not possess or purchase a firearm or dangerous weapon. Do not harass, intimidate, stalk, or threaten anyone. Specifically, do not assault, harass, intimidate, beat, molest, wound, or threaten. Do not have any direct or indirect contact with. You're not to be within 2,000 feet of where she lives, works, or goes to school. You may go to the residence one time in the presence of a law enforcement officer in order to obtain personal belongings. You must wear a GPS tether with victim notification if possible, with a exclusion zone around that 2,000 feet to assure that you're complying with the court's order. If you violate an order of no contact, sir, you could be arrested without a warrant. Your bond could be revoked. You could be in contempt of court, for which you face up to 93 days in jail and or $7,500 in fines, separate and apart from that which you already face. This order is about you. It's not about her. So if she's texting you and texting you, calling you and calling you, she is allowed to do that. You're the one under a court order. If you call her back, you risk going to jail. She does not have permission or authority to give you permission to violate a court order, because it's not her order, it's the court's order. So she invited you to go meet up with her and you went, you'd still be risking jail. You understand, sir?
Yes, ma'am.
Okay. Mr. Austin, anything else for Mr. Wallace?
Nothing additional, Your Honor. Thank you.
Thank you.
Your Honor.
Yeah.
Could you give me that bond amount one more time?
$7,000, 10%.
Okay, thank you.
You're welcome. On the record in state of Michigan versus Emily Lynn Gazar.
And good afternoon, Your Honor. Jared Austin, appearing on behalf of Emily Gazar for the purpose of this hearing only.
And is that how I say your name? Is it Gazar?
Yes, ma'am.
Okay, and are you Emily Lynn Gazar?
Yes.
Thank you. This is your arraignment. What I have here is a misdemeanor complaint that alleges that on or about June 23rd, 2023 at City of Lansing, Ingham County, Michigan, you did make an assault or assault and battery on a resident or former resident of your household, or an individual with whom you've had a dating relationship. That is a misdemeanor punishable by up to 93 days in jail and or $500 in fines. Do you understand the charge and the possible penalty?
Yes, I do.
You have the right to have an attorney in this matter. If you'd like to have an attorney and you don't believe you can afford one, we can see if a public defender will represent you. You have the right to a trial. That could be by jury At that trial, you have the right to see, hear, and question all of the witnesses against you. You have the right to bring witnesses in your own defense, and you could get a subpoena to make them appear. You have the right to testify at your trial if you wanted to, but if you did not want to testify, the prosecutor could not use your silence against you. You have the right to be presumed innocent unless they can prove that you are guilty beyond a reasonable doubt. Do you understand these rights so far?
Yes, I do.
Would you like a public defender to assist you in this matter?
Yes, I would.
Okay. A pretrial is set in this matter. That's the next step in the proceeding. Pretrial will be July 10, 2 o'clock with Judge Ward. And because it's a misdemeanor pretrial, you can do that by video conferencing if you'd like. But if you do not want a video conference, can't video conference, your phone broke, you should just come down to the court. Do not miss your court date, okay?
Okay.
All right. Now, one of the conditions of your release will be to have no contact with. Knowing that, what address should I use for you?
I'll be going to my mom's house. Of Clifford, Michigan.
You said, is that the one they have here you said Clifford?
Yes.
Okay. How far is that?
It's about an hour and 45 minutes from the house I previously lived in Lansing.
Okay. Is this phone number they gave me that ends 1826? Is that a good phone number?
Yeah, that's mine.
Okay, good. Are you on probation or parole in any court?
No.
All right, Mr. Austin, I see nothing on your client's Michigan history.
Thank you, Your Honor, and that would comport with what Ms. Gazar told me, is that this is her first offense of any kind or involvement with the criminal justice system. She's currently unemployed, but she does have a history of gainful employment prior to recently being unemployed. And as she stated, there is a separate address that she's been able to provide the court where she's going to stay while the case is pending, thus assuring the likelihood that she'll comply with the no contact order. It's also a considerable distance away. Given that, Your Honor, I think personal recognizance release would be appropriate, and that's what I would ask the court to impose. Thank you.
All right. In light of the fact that Ms. Gazar was able to give me an alternate address fairly easily as well, and this being a first offense on her Michigan criminal history, as well as the possible penalty if convicted, I will grant a $500 personal recognizance bond subject to the following conditions. A lot of boxes. Check on my form here. Okay. So you must attend all your court dates. I gave you a court date specifically with Judge Ward on July 10. Do not leave the state without permission. Do not commit crimes. Do not use alcohol or illegal controlled substances. Do not possess or purchase a firearm or a dangerous weapon. Do not engage in harassing, intimidating, stalking, or threatening behaviors. Specifically, do not assault, harass, beat, molest, wound, or threaten. Do not have any direct or indirect contact with at all. You're not to be within 2,000 feet of where she lives, works, or goes to school. If you violate that order of no contact, you may be arrested without a warrant. Your bond could be revoked. You could be in contempt of court, for which you'd be sentenced to up to 93 days in jail and or $7,500 in fines, separate and apart from that which you already face. And I know you've probably been there and you've heard me giving this speech, but I give it because it seems like people get themselves in a situation with their bond. Remember, this order is about you. It's not about her. If she's texting you or calling you, that's something that she can do. You're the one on bond. You're the one under a court order. If you text or call her back, you're the one who risks going to jail. She does not have authority to give you permission to violate a court order because it's not her order. It's my order. So if she invited you to meet up with her and you went, you'd still be risking jail. You understand how that works?
Yes, I do.
Okay. All right. We've covered the bond conditions, the court date. Mr. Austin, anything else for Ms. Gazar?
Nothing further, Your Honor. Thank you.
All right. I do believe you're all set.
Thank you.
You're welcome. On the record in state of Michigan versus Michael Atron Johnson, 2301872 FY.
And good afternoon, Your Honor. Jared Austin appearing on behalf of Mr. Johnson for the purpose of his arraignment only.
And are you Michael Johnson, sir?
Yes, Your Honor.
Today's the date for your arraignment. What I have here is a felony complaint. This alleges that on or about June 8th, 2023, in the city of Lansing, Ingham County, Michigan. Count 1, assault with intent to do great bodily harm, less than murder, or by strangulation, that you did make an assault upon a by strangulation or suffocation. That is a felony punishable by up to 10 years in prison and or $5,000, DNA to be taken upon arrest. Count 2, interfering with a crime report, committing a it says committing a crime threatening to kill or injure. You did, through the unlawful use of physical force, prevent or attempt to prevent another person from reporting a crime committed or attempted by another person. And the violation involved committing or attempting to commit interfering with telephone communications against a person or threatening to kill or injure a person. Felony 10 years or $20,000. A consecutive sentence may be imposed for any other conviction. Count 3, interfering with electronic communications, that you did willfully and maliciously prevent, obstruct, or delay by any means the sending, conveyance, or delivery of an authorized communication by or through a telephone or telephone line. Felony 2 years and or $1,000. Count 4, domestic violence, that you did make an assault or assault and battery upon an individual with whom you've had a dating relationship. That normally would be a misdemeanor of 93 days, but this has a second offense notice that says, take notice defendant was previously convicted of assaulting and battering his spouse, former spouse, an individual with whom he's had a dating relationship, individual with whom he had a child in common, or a resident or former resident of his household, or of knowingly assaulting a pregnant individual on or about April 13, 2023. Therefore, upon conviction, will be subject to an enhanced sentence, misdemeanor, 1 year and or $1,000. Count 5, assault and battery, that you did make an assault or assault and battery upon the following person. Misdemeanor, 93 days and or $500. Count 6, assault and battery, that you did make an assault or assault and battery upon the following person. Misdemeanor, 93 days and or $500. Count 7, that you did make an assault or assault and battery upon the following person. Misdemeanor, 93 days and or $500. Do you understand these 7 charges and the possible penalties?
Yes, Your Honor.
You have the right to have an attorney in this matter. If you'd like to have an attorney and you don't believe you can afford one, we'll see if the public defender will represent you. You have the right to a trial. That could be by jury. You have the right to remain silent. Anything you say orally or in writing will be used against you in court. You have the right to have an attorney present with you during any questioning by law enforcement. Do you understand these rights so far?
Yes, Your Honor.
Would you like a public defender to represent you in this matter?
Yes, Your Honor.
Put down that you've made an application. Now, because you have felony charges, you do have the right to a preliminary examination. That's a hearing where the government must bring some evidence to demonstrate probable cause to believe that the felony charges occurred and that you are the person who committed these felonies. Before that day, you will have a probable cause conference, a day where you, your lawyer, the prosecutor, all assure that you have all the evidence and information you have to be ready for a preliminary exam. Your probable cause conference is scheduled for July 7 at 8:30 a.m. with Judge Simmons. And you will have a preliminary exam on July 14, 8:30 a.m. also with Judge Simmons. That first hearing can be done by video conference like we're doing right now, but that second hearing is an evidence hearing. Therefore, you must be here in person in Judge Simmons' courtroom on that July 14 date. You understand?
Yes, Your Honor.
One of the conditions of your release will be to have no contact with any of these people. Knowing that, what address should I be using for you?
10.
Whose place is that?
My mom.
Your mom? Okay. let's see here. They didn't give me a phone number. Is there a good phone number you can be reached at?
Yes, 616.
Okay, I do have Mr. Austin a bond request from the prosecutor. This says they are making this recommendation for protection of the public, that the defendant is on parole, probation, or pending other criminal charges. These crimes involve violence towards another person. The defendant has a history of violent behavior directed towards the victim, a history of threatening and or harassing behavior toward the victim or witnesses, and this involves an intimate partner. There have been threats to kill the victim or family, stalking behavior, recent separation or divorce, escalation of violence, or risk-taking over time. The victim has a PPO against the defendant. Domestic violence victim had a PPO in place and multiple court no contact orders from probation. The defendant was sentenced on June 2nd, 2023, and pled on 2 different DV assault dates to domestic violence. Defendant has prior dismissed DVs and assault and batteries, and in this case, he strangles the victim and then assaults 3 other women who are attempting to help victim. The victim said defendant has been staying with her since he was released from jail June 2nd, and there are so many prior domestic violence assaults she cannot count. This defendant has previous witness interference tactics to avoid accountability. Lethality factors are high in this case, which include strangulation, escalation of violence, threats, violence in front of witnesses, violence towards not just the intimate partner, but also anyone in the way of him assaulting his intimate dating partner, violations of no contact orders, etc. Defendant is a danger to society and all 4 victims in this file. The people respectfully request a high cash bond of $100,000 given the level of danger while on probation for assaulting the same victim. If released, defendant should not be released without a GPS tether with victim notification for all 4 victims. However, the people do not believe GPS tether is going to make society and the victims safe. Okay. All right, I just want to look at his criminal history. I believe I have it here. So it looks like your client is currently on probation for 2 files. Is that right?
That's my understanding, Your Honor, with Judge Simmons, I believe.
Okay. All right. On bond, sir.
Yes, thank you, Your Honor. As the court's aware, Mr. Johnson is currently under supervision with this court. He also has long-standing ties to this community as well as family ties. He is going to be living with his mother and maintaining a separate residence to help him abide by that no contact order. I didn't see or hear anything that led me to believe that he has a history of failing to appear for his court dates. The allegations in this case are assaultive in nature and they are serious. However, Mr. Johnson doesn't enjoy the presumption of innocence. I would ask the court to take all that in consideration and consider releasing Mr. Johnson on a reasonable 10% bond that he could reasonably have a chance of posting. Thank you.
Do you know if his probation prohibits contact with Ms.
I believe that it does. From what I know about that case, I believe that at least one of those cases, I think, likely involved Mr.
Well, I just don't know if that no contact order continued as a condition. It doesn't always. Let's see. I might be able to figure it out. He has a pending probation violation.
If I may, Your Honor, according to the notes in our file, when Mr. Johnson was sentenced, looks like back earlier this month, he was sentenced to 9 months of probation, and it does mention a no contact order with.
Thank you. Yeah, I definitely see that. Okay.
That was in file 23860.
Yes. Due to Mr. Johnson being alleged to be on probation for 2 assaultive type offenses relatively recently sentenced and then is alleged to be almost immediately in violation of a specific probation condition of no contact, and then ultimately a 7-count complaint of assault. PR bond obviously is not going to protect the public. He was already under court supervision, and it sounds like whether there was an assault or not, he was immediately in violation of a court order. Bond will be set at $150,000 cash surety, subject to the conditions. Must not leave the state without permission of the court, do not commit crimes. You must attend court dates. I gave you 2, July 7, July 14. You must report to pretrial services on the first business day following your release. You must notify the court in writing of a change of address or telephone number. Do not use alcohol, marijuana, illegal controlled substances. Do not possess or purchase a firearm or dangerous weapon. Do not engage in harassing, intimidating, stalking, threatening behavior. Specifically, do not assault, harass, intimidate, beat, molest, wound, or threaten. You are not to have any direct or indirect contact with any of the named people. You're not to be within 2,000 feet of his homework or school. You are to wear a GPS tether for purposes of monitoring your compliance of that order with victim notification, if possible. The zone will be established around Miss residence to monitor the 2,000 feet. You violate an order of no contact, you could be arrested without a warrant, your bond could be revoked, you could be in contempt of court, for which you face up to 93 days in jail and or $7,500 in fines, separate and apart from that which you already face. I know you've heard me say this to others. This order is about you. It's not about these other people. If they're texting you or calling you, they're allowed to do that, but you're under a court order not to. If you text or call them, you're the one who risks going to jail. They do not have authority to give you permission to violate a court order because it's not their order, it's the court's order. So if they contacted you, asked you to meet up, and you went, you still risk jail. You understand, sir?
Yes, Your Honor.
Since I do believe it's possible you will be in jail, it's important that you understand that this order of no contact applies even while you're in jail. And the prosecutor makes it his business to listen to your phone calls. So if you start contacting one of these witnesses while you're in jail, the prosecutor will, firstly, pull that call and use it against you. Secondly, you may incur additional felony charges of witness interference. So remember, this order applies even while you're in jail. Mr. Austin, anything else for Mr. Johnson?
Nothing additional, Your Honor. Thank you.
Thank you. Your stop, Mr. Johnson. This is State of Michigan versus Laura Chi, 2301693SM.
And good afternoon, Your Honor. Gerald Austin appearing on behalf of Ms. Chi for the purpose of her arraignment only.
All right. Is that how you say it? Is it Chi?
Yes, Your Honor.
And you are Laura Chi?
Yes.
All right. Ms. Chi, you're here for arraignment on a alleged violation of your bond. The notice I have here says that you were arraigned back on June 1st and you were ordered to have no contact with and you were not to be within 2,000 feet of where he lives, works, or goes to school. It is alleged that you violated that court order by having contact with and being within 2,000 feet of where he lives, works, or goes to school on June 23rd, 2023 at about 12:18. Now, if you violated an order of no contact, of course, you'd be arrested. Your bond could be revoked, but in addition, you could be in contempt of court. Contempt of court is punishable by up to 93 days in jail and or $7,500 in fines, separate and apart from that which you already face. So you do have the right to have an attorney in this matter. Mr. Austin, does your office already represent Ms. Chi?
Yes, Your Honor, we do.
Who has the case? Do we know?
Mr. Raleigh.
Okay.
Looks like it's set for a pretrial conference on July 11th.
Okay. All right. Represented by Mr. Raleigh. All right. You have the right to have a trial, not by a jury, but just by a judge on contempt of court. However, it would have to be proven that you did violate a court order beyond a reasonable doubt. You understand the possible penalties of contempt of court?
Yes, Your Honor.
The court order says no contact with, but I think his last name is actually. All right, Mr. Austin, I guess I'm not sure there's conditions of release that Ms. Chi will follow. I mean, it looks like she's arraigned June 1 and by June 23rd, she's not following the court orders, and it is alleged that police officers witnessed her there. So it's not even a case that depends on whether Mr. will show up for court, but instead police may have witnessed this. Do you have a proposal as to release for Ms. Chi?
Yes, thank you. What I can say is I'm not privy to the report. I don't know what the extent of the allegations are, whether there's allegations of violence or not attached to the no contact order violation. However, I know the court treats these court order violations very seriously. But what I can say is Ms. Chi has been afforded at least personal recognizance bond up until now. I know I've had additional opportunity to speak with her as to just the extent of how serious an allegation like this is and how serious the court is going to treat these orders. And this is something she's going to have to strictly comply and abide with. And given that, Your Honor, doesn't appear from speaking with Ms. Chi that she has any extensive criminal history. I would ask the court to consider continuing her on the bond that she already has. If the court believes that is insufficient, then I would ask for some low monetary amount that Ms. Chi would have to oppose pending this PA 53 violation, or additional safeguards or bond conditions to give the court additional assurance that she will be fully compliant with the court's orders. And I'm hopeful that she will be. Thank you.
Your Honor, could I add something?
I don't know if it's a good idea. That's why you have a lawyer here talking for you.
Okay.
Okay. Well, in light of the allegation that bond was not followed, and really quickly not followed, bond will be set at $1,000, 10%, with all the conditions that were in place, plus the added condition of GPS tether with a zone around in order to monitor Ms. Chi's compliance with bond. So Ms. Chi broke the court's trust allegedly, and therefore there will be additional safeguards put in place at this time.
Okay, can I add something? It's my place of residence. When I went back to that residence, he was not there. He tried to show up to the residence, and I called the police, so he left, and then 2 hours later.
So you're making a lot of incriminating sort of statements right now. That's what you're doing, and that's why we tell you not to talk. So I will tell you this. Whether it's your lease or his lease, the court does not care. You've been ordered not to be there. So if he were staying there, even if it was against your will, it would not matter. You've told not to be there. In addition, if he showed up there and he wasn't supposed to be there, he was not your guest, the appropriate response would have been to call the police and report him for trespassing. Stop. You're not understanding. See, every word coming out of your mouth makes me think you're not getting it, and therefore this bond is not going to be trustworthy. Because I'm telling you, and you were told not to be there. You gave a different address when you were arraigned on Elm. So I don't know why you're back at K North and now claiming that you should be there and he shouldn't be there. So we'll sort that out at your hearing. We'll sort it out at your hearing. I'm done.
And I went to the emergency room.
Stop talking. You're not helping yourself. You're all set. I've set your bond.
And Your Honor?
Yep.
Will that violation hearing be set the same day as the pretrial conference, or do we know?
We don't know for sure. The clerks will try to set it when they come in. I know we like to set them quickly, especially if someone's been unable to post. So depending on whether she posts that bond or not might determine that. Okay. But also, I'm not in on the 3rd. It's a holiday, the 4th, create some complications in there. We have one more to see. That's Virginia McInhill. Okay. It looks like this is a 55th District Court bond that I'm going to be arraigning. This is State of Michigan versus Virginia Rose McInhill. 55th District Court number 2300396 SM.
And good afternoon, Your Honor. Jared Austin appearing on behalf of Ms. McInhill for the limited purpose of this hearing only.
Really curious well, I guess I'll find that out another day, but I'm thinking that they could have got the district court judge in 55th to arraign her today.
That's what I was expecting, but
here we are. Maybe because LPD took the report. And are you Virginia McInhill?
Yes, Your Honor.
All right, thank you. Where's the circuit court bond? I'm looking, no, this is super recent, so I'm guessing no. Okay, Ms. McInhill, it is alleged that you violated conditions of bond. It says here that you had a bond set for you by Judge Hillman on June 20th of 2023. Conditions of that bond included not to have any contact with and it is alleged that on June 23rd, 2023 at about 5:10 p.m. that you violated this order by having some kind of contact with. If you violated an order of no contact, you can be arrested without a warrant, hence you're in jail right now. Your bond could be revoked, a new bond could be set. You could be in contempt of court, for which you'd face up to 93 days in jail and or $7,500 in fines, separate and apart from that which you already face. You have the right to have an attorney in this matter. If you cannot afford one, a public defender may represent you. Mr. Austin, does your office already represent her in this matter?
Yes, Your Honor. Mr. Tyler Smith represents her in this case.
All right. Ms. McInhill, you do have the right, if the judge proceeds on contempt, to have a trial, not by a jury, but just by a judge. It would have to be proven beyond a reasonable doubt that you did, in fact, violate a court order. It's alleged that this event occurred at the Meyer gas station on Pennsylvania here in the city of Lansing. Hence, LPD took the report, and LPD witnessed and was present when they allege Ms. McInhill was in the presence of Ms. violation of this order. Mr. Austin, it's not my file, so I guess I'm not really sure what I want to do. But did you have anything for bond consideration?
Just what I would say, Your Honor, is Ms. McInhill is out on a personal recognizance bond. At least it sounds like the allegation that this occurred in some type of public setting, so it doesn't appear that there's an allegation that one went to the residence of the other or anything like that. I don't know if this was a situation where they ran into each other and didn't leave quickly enough. I don't know. But I would just ask the court to continue to release Ms. McInhill on the bond that she currently has posted. The court can add additional safeguards or other terms and conditions to add some additional assurances. But I have reinforced to Ms. McInhill just how serious these allegations are and how seriously the court treats these kinds of allegations on violation of the court's order. And I'm hopeful that she will be fully compliant. Thank you.
Based on the allegation of a violation of an order of the court, very quickly after the order was put in place, is alleged to have been put in place on June 20, and by June 23rd, it is alleged that she's being witnessed to be in the presence of the prohibited person at the Meyer gas station during a UTA investigation. It does not seem that the personal recognizance bond was effective. The court will initiate a new bond of $2,000 cash surety, subject to the conditions substantially similar to that which the judge already had in place, which are: do not possess firearms, ammunition, do not engage in assaultive or threatening behavior, do not assault, harass, intimidate, wound, or threaten, do not have any direct or indirect contact with. Okay, I think that sums up the conditions. All right. think that covers it. Mr. Austin, anything else?
I have nothing further, Your Honor. Thank you.
All right, thank you. And I think that concludes our arraignments. Is that right?
Yes, Your Honor.
Okay, thank you.
So, that was a fun little adventure. Anyways, thank you, Chimagwitch, for joining me and watching today. Don't forget to like and subscribe. And every Thursday at 1:15 p.m. is my weekly live stream where I cover court cases, because that's what this channel is. Anyways, Chimagwitch, thank you for watching, and I will see you next time.